How are easement maintenance responsibilities determined? Imagine owning a property with a shared driveway or utility line running through it. Who is responsible for keeping it in good shape? That depends on several key factors. First, the type of easement matters a lot. An easement appurtenant benefits one piece of land, called the dominant estate, and usually passes with the property when it is sold. In this case, the owner of the dominant estate is typically responsible for maintenance because the easement directly benefits their land. On the other hand, an easement in gross benefits a person or company rather than a specific property. For example, a utility company that has an easement to run power lines across your land. In these situations, the benefiting party generally handles maintenance because they are the ones using and benefiting from the easement. Next, the written agreement or deed that creates the easement often spells out who is responsible for maintenance. These documents can specify exactly what each party must do, how often, and who pays for repairs. It is very important to review these papers carefully before buying a property or using the easement to avoid surprises later. Use and shared use also influence maintenance duties. If several people or entities share an easement, like a driveway or path, they usually divide the costs based on how much they use it or how much damage they cause. For example, if one neighbor uses the driveway more often, they might pay a larger share of repairs. When the land that hosts the easement, called the servient estate, also uses it, costs are often split fairly between both parties. Local laws and customs can also play a role. Some areas have rules that clearly define maintenance responsibilities, but many relying on agreements or common practices. If there is no clear rule, disputes can happen, and parties might need legal help to settle who pays for what. A common mistake is not having a clear written agreement about maintenance. This can lead to disagreements and costly legal fights. Another mistake is assuming responsibilities without checking the easement documents or local laws. Ignoring shared use factors can also cause unfair costs or conflicts. To avoid these issues, property owners should get or create clear maintenance agreements that specify who does what and who pays. Reviewing the easement deed carefully before buying or using the property is a smart move. Open communication with other parties involved helps prevent misunderstandings. If responsibilities are unclear or disputes arise, consulting a legal professional can save time and money. In the end, how easement maintenance responsibilities are decided depends on the easement type, what the documents say, how the easement is used, and local rules. Having clear agreements and talking openly with others involved can keep property owners from running into legal problems over easement upkeep.